Hello and welcome to the third and final video in this series on Chapter 4 of Government in America. Um, Having just talked about the Fourth Amendment, we'll talk about the Fifth next, which is uh, with the Fourth and Sixth in particular, very important in sort of laying out how the government has to go about investigating somebody and making sure that if they want to throw somebody in jail, they're following some sort of established rules. So the Fifth Amendment establishes the rights of the accused. First of all, if the federal government wants to put somebody on trial, they first have to get the indictment or the charges approved by a grand jury. That's a group of citizens who look at the evidence and say, yes, prosecutors, we think you have a case here. The federal government can't just say, snap their fingers and make somebody be on trial. You have to present the information to this grand jury. Now, in practice, many times the grand jury will say, okay, we trust you, Mr. Prosecutor or Madam Prosecutor, so we'll indict the person that you want us to indict. The joke is that a lot of times a prosecutor can get a grand jury to indict a ham sandwich if the prosecutor really wants to. But that's not always the case. It's possible sometimes that the grand jury would refuse to return an indictment. And the Constitution ensures that at the very least the prosecutors have to overcome that hurdle. In addition, the Constitution means that the government cannot force you to testify or give evidence, spoken evidence, testimony that might make you look guilty for something. This is called self-incrimination. Incrimination is, making someone look guilty. So self-incrimination is making yourself look guilty, and you can't be forced to do that. So if you're a defendant, you cannot be forced to testify at your own trial. Many times the defendant will not testify, and the judge will remind the jury, you can't take that as proof that the person's guilty. The person has the right to stay silent. If you're a witness in some other case, but the testimony that you give in that case would make you look guilty for something different, the government can't force you to do that. So let's say that someone's accused of murdering someone in Northeast Philadelphia, and you know that that person could not have committed the murder in Northeast Philadelphia because at that time they were helping you rob a bank in South Philadelphia, and the person wants you to be their alibi witness in court. Well, if you testify, then you're making yourself look guilty of bank robbery, and you don't want to do that. The Constitution says that you can, what's what we call pleading the fifth. You can refuse to testify because it would incriminate you. So you can say on Fifth Amendment grounds, I'm refusing to testify. That's where the whole idea of you have the right to remain silent comes from. You don't have to answer questions if answering those questions might make you look guilty. Because let's not forget, you can look guilty but be innocent. And that's definitely a valid concern that people would have. So that's one of the reasons why we have this right. Another right that the accused have is you can't be put on trial twice for the exact same crime. So if the government accuses you of bank fraud and they have the trial and you're found not guilty, they can't say, well, all right, well, we're going to charge you again. And we're going to keep charging you until we find a jury that likes us. They can't do that. That's called double jeopardy, putting you in danger twice from the same crime. Can't happen. Now, if they think that you've committed bank fraud in a second separate instance, they could charge you with that. But they can't charge you twice with the exact same crime. Once you've gone through a trial once, it's done. It's over. That's, again, it's called double jeopardy, and double jeopardy is not allowed. The Fifth Amendment protects you against double jeopardy. Um, Another thing that the Fifth Amendment protects you from is the government just making things up as it goes along in terms of how they're going to investigate you. Um, the government has to follow a certain procedure and follow that procedure for everybody. That's what we call due process. Your due process is the process that is due to you, uh, that you are owed. You are owed that the government will follow the same procedures that it follows with everybody else, and it's not going to do things that are going to give you an increased chance of being put in jail. So if someone says that they haven't been afforded or given their due process, it means that they think the government cut some corners and treated them unfairly. Um, Finally, there's another protection in the Fifth Amendment that might not sound like a protection. Uh, the government does have the power to take land or property away from people who own it. That's called eminent domain. Um, so if the government wants to build a road through a certain place because the community needs that road and your house happens to be in the way, the government can use the power of eminent domain to say, look, we need that land. But the government can't do it without compensating you in some way. They can't just say, hey, we're taking it, you're out of luck. They at least have to say, okay, this is what this is what we owe you for the land that we're taking. So that's it's a protection that'll hopefully stops the government from totally abusing a power that they have, which is the power of eminent domain. Just like the Fourth and Fifth Amendments, the Sixth Amendment also covers things with the government is trying to investigate and hold someone accountable for a crime. So there are numerous rights of the accused that are included in the Sixth Amendment. You have the right to a speedy trial. The government can't throw you in jail and say, oh yes, we're going to put you on trial in 10 years, and until then you're just going to have to wait here in prison. No. The government has to get the process moving and move it at a reasonable pace. Now, a reasonable pace for our legal system might mean 6 months, a year, something like that before your trial starts. But they can't just throw you in jail and then forget about you while we're waiting for a trial. And then once that trial starts, if you want, you have the right to a trial by jury. You have the right to have a group of your fellow citizens hear the evidence and decide whether or not you are guilty. You have the right to know what you've been charged with so that you can prepare your defense. The government can't say, oh yes, we're charging you with littering, and then at the very beginning of the trial suddenly surprise you and say, oh yes, and in addition, because somehow we think your littering led to the death of a person, we're also charging you with murder. No, they can't do that. They have to give you the charges ahead of time so that you can prepare for it. Once you know the charges, you have to be able to put together a solid, credible defense. So if there are witnesses against you, you have to know who the witnesses are. You have to be able to hear their testimony. You have to be able to have you or your representative, your attorney, ask them questions to try and poke a hole in their story, which is what we call cross-examination. If there are witnesses that could help you, you have the ability to call them and require them to come testify and testify truthfully. With the exceptions that we talked about with the Fifth Amendment and the right to avoid self-incrimination. And if all of this sounds like it's too much for you to handle, well, you have the right to have an attorney, someone who will know the law and know the system to be able to represent you and not let you be run over by what the courts have to say. So these are all significant rights that are held by the accused. Another amendment that provides us with protection from the government abusing its power is the Eighth Amendment, which says that the government is not allowed to use cruel and unusual punishment. What does that mean? It means the punishment has to fit the crime. We're not going to throw you in jail for 40 years for jaywalking. The punishment can't cause unnecessary suffering. So we can't make you run laps every day until you nearly fall over and collapse and have a heart attack. Can't do that. We can only use punishments that are appropriate and are sort of considered acceptable by society. Now, up until now, the courts have ruled that the death penalty is allowed, that the death penalty is not cruel or unusual, but the execution has to be done in a humane way. So you can't shoot someone in the stomach and wait for them to bleed to death painfully. Now, this has caused some issues lately because people keep saying that the ways that we go about doing executions in states that have executions are not the most humane way that you could kill somebody. So there's actually an argument about what is the appropriate way to kill someone if the state and the courts have decided that someone has committed a crime that they deserve to die for. And the courts are still arguing over that. As we speak, there are cases that are before the Supreme Court to cover that issue. So that's the Eighth Amendment. That's what bans torture. Now, in the course of all of these amendments, we have not talked specifically about the right to privacy, because the Constitution does not specifically say that there is a right to privacy. The word privacy isn't anywhere in the Bill of Rights or anywhere else. What has happened is the Supreme Court has looked at the rest of the Constitution and has looked at specific cases and said, if you put all of these rights together, they sort of add up and establish that people must have a right to privacy. They must have a right to keep parts of themselves and their lives to themselves and not have the government mess with them. There are two very famous cases that have to do with the right to privacy. The first is a case called Griswold versus Connecticut, which is a case that established that the government cannot make birth control illegal. If I am, if I'm in a relationship and my partner and I don't want to have children and we've made that decision for ourselves, so we want to use some kind of medically approved birth control system, we can do that. Griswold versus Connecticut says that I and my partner have the right to not have the government interfere with our personal, private decisions in that way. A few years later, after Griswold versus Connecticut, the Supreme Court kind of extrapolated further from that and made its decision in the case of Roe versus Wade, which said that the government can have regulations on abortion, but they cannot outlaw it altogether. That at least early on in the pregnancy, especially, the biological mother, because the biological mother has authority and sort of control over what's going on inside her body, this right to privacy and preventing the government from taking control of things means the government can't tell her what to do about her reproductive system. And so that is where the decision in Roe versus Wade came from this idea of a right to privacy, which isn't in the Constitution itself, but was interpreted from the other rights that are in the Constitution. So that will conclude our discussion of civil liberties for now, and it will come up in other cases, but I leave you with a couple of sets of questions to think about. Take care.